got your address in the first lines. You put who the contract is with. If you're a subcontractor, you put that you're with that the contract was with the general contractor. If you're a general contractor, you put the contract was with the owner, and then you put that address as well. Then you put the property. You got to put the county that the property is located in, because this has happened. I'll tell you what, my office is also screwed up once, where my secretary sent a lien, and thank God the recorder caught it. I put that the property is in Miami-Dade County. My secretary sent it to Broward County. It would have been completely useless. I would have blown my lien rights. I would have committed malpractice because my secretary sent it to the wrong place. Well, thank God they sent it back. So it's important that you actually put in there what county it's supposed to be recorded in. And they actually do examine it. I'm not saying that they're always going to catch it, but I got very lucky. I'll tell you quite frankly. Believe me, she knows now.
That's the county where the job is.
Yes. Yeah, exactly. So, next thing, you got the legal description of the property. Usually that's obtained from the deed. As one person said, you don't really look at the notice of commencement. You're going to want to look at the deeds and find out exactly what the legal description of the property is. Next line. It says, said labor, materials, and or services were of a total value of blank dollars. This is where I see people screw up. It's not really too material, but remember, this is a sworn affidavit. At the end, you will be asked to be sworn and state this under oath as to the truth and veracity of this document. So when it says said labor, materials, and or services were of a total value of, a lot of people think that they just put that contract value in there. Maybe, maybe not. Let's assume you get terminated in the middle. You've done, again, $70,000 worth of work, you get terminated. Well, and your contract was a $100,000 contract. You can't swear and say, said labor, materials, and or services were of a total value of $100,000, because that's not what you've done. You have to put actually what has been done, and then the next line says, of which there remains unpaid blank dollars. So if you've done $70,000 worth of work, and you're unpaid $20,000 at that draw, then you put $70,000 and $20,000. You don't put, I've done the entire contract, $100,000, of which there only remains $20,000 unpaid. So you just need to watch your numbers. And remember, what we talked about before is what is lienable. That second line is the most important line to me of this whole document, because that's what I'm always looking at. I'm checking numbers. I'm going through pay requests. I'm going through G702s and schedule of values, and I'm looking to make sure that is everything that is included in there lienable. If it's not, I'm filing a counterclaim against you for fraudulent lien. Okay? So make sure that everything that you've done, it's better to be under than over. If you think that there's even a question, go through my chart, look and see, is this lienable? Is it actually incorporated for the permanent benefit? If not, don't include it. Next line, this is also super important as well. The first of said labor services, said labor, materials, and or services were furnished on blank day. Why is that one important? Why is it important that I know when you start? Because you have, what?
The 90 days?
No, that's going to be the next line. But why is it important when you start? Because, look, I've been involved with contracts where they start in 2006 and they're ending in 2008. Or years have gone by. Remember, you only have 90 days to claim a lien from when you last furnished any labor, services, or material. I'm talking about why is it important when you first begin. For a general contractor, it really isn't. I couldn't care less. But if you're a sub, or one of those people that's required to serve a notice to owner, a material supplier, I'm looking at that day, and then I'm looking later on in this document, you're going to have to put in when the notice to owner was served. And if I see that you first commenced on January 1st, and your notice to owner was served outside of 45 days from there, I don't have to go any further. I'm sitting back, I got my feet on my desk, this case is done. The lien is gone. Because right there, you've already sworn to and said that you're outside of the 45 days with your notice to owner. That sub or that material supplier or whoever it is that is required to serve the notice to owner has no lien rights. Again, for a general contractor, that's not going to help me. That's in direct contract with the owner, because they don't have to serve a notice to owner, so I couldn't care less about that day. It's interesting. It may help me out in some other facet of the case. Maybe a delay claim, but it's not going to have any effect on the lien. So what about the next line? And the last of same on blank day. In other words, what's the last day the labor, services, and material were furnished? This gets back to exactly what you said. For purposes of the claim of lien, time, no matter who it is, only has 90 days from the last day of furnishing labor, services, or material to record the claim of lien in that county. In Dade County, it's the clerk's office. You go down, it's right next to the courthouse, or you can go to any courthouse in Miami-Dade County and record the claim of lien. In Broward County, there's a Broward County administrator's office or something that's in Fort Lauderdale. Well, let's assume that the last day, according to this claim of lien, let's assume that it says